Question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. No. No's have party vote. The clerk will conduct a party vote.
New Zealand National.
8 votes opposed.
New Zealand Labour.
43 votes in favour.
Green Party.
9 votes. 9 votes in favour.
ACT New Zealand.
5 votes opposed.
Māori Party.
5 votes in favour.
Progressive.
1 vote in favour.
United Future.
1 vote opposed.
Shame.
The ayes are 58, the noes are 64. The motion's not agreed to. Call members, order of the day number 1.
Public Works Offer Back of and Compensation for Acquired Land Amendment Bill, second reading.
To Ura Flavel.
Mr Speaker, I move that the Public Works Offer Back of and Compensation for Acquired Land Amendment Bill be now read a second time. Hoi anō kia ora tātou e te whare, i te tuatai hei wāhi waku kōrero ka huri te titiro ki a koe kei taku rangatira e tau, ko hoki mai koe ki tō whare, nau mai hoki mai me tō ate hou, hei whakahihi ki te ngākau, ka mutu e hari kona ko hoki ora mai, nau mai hoki mai. O tira ki a tātou e hoa mā, mo te ahutango ngā mate o te wā, waiho rātou ki a moi, anei tātou ko hoki mai ki roto i ngā pakitaro te whare, tēnā koutou kia ora tātou. Ko tā koe te tuatahi e mihi kawatu ki te komiti nā rātou tēnei pire i titiro i tōna i ngā marama ko hipa. Ka mihi rā ki te Local Government and Environment Committee. Ka nui e hoa mā, tēnā koutou katoa. Ka nui te mihi ki a Chris Arkenville, te tiamano taua committee, i whakatūwhere nei te kuaha ki a tai atu ahau ki te whakatakoto i ngā kōrero e pāna ki tēnei pire. Ki au nei, i āhua areare mai ngā taringa ki te tikango taku pire, ka mutu ahakoa e āhua uaua ki ētahi, ko te mea nui i tae mai ngā tāngata o te motu ki te whakatakoto i o rātou whakaro ki mua te komiti, ka mutu i rongo te komiti i ngā kōrero. Te āhua nei e kore pēr e eke ki te taumata i wawata tia mai ai, i ngā marama ko hipa, engari ko te mea pai i kōrero hia i wānanga hia. No ira ka nui te mihi ki a koutou katoa, i kaha rongo nei i te tikango tēnei pire. Mr Speaker, the Waitangi Tribunal's He Mau Ngā Rongo, the report on Central North Island Claims 2008, stated that the taking of lands in the CNI is a major grievance, that the compulsory taking of lands without consultation, in some instances with no compensation, by legislation unsanctioned by Māori communities, has given rise to an enduring and profound grievance. End of quote. So this bill, the bill that I put forward, responds to this challenge to address the enduring and profound grievance of the legislative history that has been, which has been unsanctioned by Māori communities. So Māori land has been taken both under the Public Works Acts for a specific purpose and for and or purchased by the Crown for specific purposes over the years. In most instances, land sold to the Crown for a specific purpose is only sold by Māori for that specific purpose and for no other. It is with that principle in mind that the bill proposes, this bill that I've had on the books for some time, proposes that the bill proposes that land sold to the Crown should be offered back to the original owners and or their descendants, or that compensation be offered. And that was the point of the bill. Mr Speaker, we have a legacy of Waitangi Tribunal reports in this land which suggest that the Crown has historically failed to honour its obligations and responsibilities as articulated in Article 2 of Te Tiriti o Waitangi. They have spoken in the strongest terms that the Crown has an obligation to protect Māori land for use by Māori for as long as Māori wish. We know too that the evidence of these words is revealed with the amount of land taken from Māori by the Crown and their agencies using the various tranches of Public Works Act over successive generations. So during the Select Committee process, submitter after submitter, when describing the way in which Māori land had been taken in a disproportionate manner over the decades, told us that the Public Works Act 1981 created discrimination. Atareta Puananga shared her views of the way in which the Waitangi Tribunal's reports have dealt with public works takings, and talked about the fact that they have described what she called a crucial insight into the human cost of Crown policies and practices. In the Turangi Township report, for example, the tribunal described the statutory powers of the Crown as, quote, draconian, and that many, quote, suffered grievous spiritual loss, the scars that remain today, end of quote. So she reported that the Crown operated from the worldview that assumes that the inherent superiority of certain values and beliefs which are firmly rooted in Western law are the only way to go. Her challenge to the committee was that tikanga Māori should be elevated to the same status as tikanga Pākehā. She also advised the Select Committee of the view Te Rōpū Arataki, a group of Māori who were considered to combine a specialist technical focus with knowledge of tikanga. Te Rōpū Arataki assisted Land Information New Zealand on policy development to a review of the Public Works Act. It was their unanimous opinion that not one more acre of Māori land should be taken for public works purposes. So I might add that this has been the phrase that my colleague Hone Harawira has upheld in the last couple of days. In fact, he's breathed new life into that phrase, which originated from the Māori Land March to Wellington 35 years ago, which had as its slogan, as I say, not one more acre, because Māori were scared about how much Māori land was being gobbled up by the Crown. Such is the passion that many of our people have in wanting to retain their land, that this bill, Mr. Speaker, is related very much to the passion that there are people sing about, still continue to sing about, and in some cases even march about. So my view, sir, is that this bill had the most honourable intentions. The bill proposes amendments to the Public Works Act 1981, specifically Section 40, in order to firstly ensure that former owners of land who have been deprived of that land by the Crown for the purposes of a public work are given the first right of refusal to purchase that land where the Crown no longer requires it for the particular public work for which it was originally acquired. And secondly, provide for salatium payments for former owners of land deprived of their land for the public works purpose for which the land was never actually used. And thirdly, it provides for the descendants of the former owners to exercise the rights set out in subsection 1 of this section where the former owners are deceased. Mr. Speaker, I've read the views of the Land Information New Zealand organisation that the purpose of the bill is already met by current mechanisms for redress, for compensation and offerback available through the court system and Te Tiriti o Waitangi settlements process. But, sir, I would put forward to the House that the very solid evidence that came out of approximately 71 submissions on the bill told us that all the legal and Māori submissions were actually in favour of the bill's proposals. Mr. Speaker, I understand that the Select Committee does not want the bill to proceed. That's a little bit disastrous. That's their view, and there's little that I can do too much about, unfortunately. But, sir, I would strongly commend at least recommend that Section 40 of the Public Works Act and the incidental sections should be reviewed. It is my strongest view, sir, that the Crown has a treaty obligation to protect, to preserve and promote the retention of Māori land by Māori by adopting policies and practices which facilitate this obligation. Given the major role that the Crown has played in the disposition of Māori of their land, the Crown must have a major role in rectifying the critical land loss situation that Māori confront in 2010. Sir, the disposition of land from Māori is an indictment on the Crown. We will never forget that where Māori once held 660 million hectares in 2010, now Māori control less than 6% of the landmass of Aotearoa. And we say, not one more acre. Sir, the Public Works Act as a whole was often used in unscrupulous ways. While